Good evening. Welcome to this event tonight, hosted by Green Springboard. Hopefully you can see my screen. I'm sharing some slides tonight. First things first, I'll just better introduce myself. Obviously, I'm there on the first slide. My name's Gareth Bramley. I'm a senior tutor at the University of Law. I was a former commercial litigation solicitor in practice prior to being a senior tutor. I will let Chris introduce himself in a moment, but just a couple of housekeeping points before we start. Obviously, this event tonight is being recorded, so if you are not happy to be recorded in terms of your video, if you want to turn that off and obviously keep yourself muted. What we'll try and do is take some questions at the end if that's okay, but feel free to use the chat box function as we go through, and we'll try and pick up some of those at the end. Obviously, as I say, big thank you to Green Springboard for hosting the event tonight and for inviting both of us on here. We've got a few things to take you through tonight. I know we've got a range of different people who have signed up for the event and who might be watching this video after the event from a range of different businesses, so we hope to be able to cover a variety of points. So that's me. Chris, do you want to introduce yourself?
Yep, my name's Christopher Johnston. I graduated from the University of Sheffield with a law degree about 3 years ago now, and I've worked in 3 solicitors based in Sheffield at the moment in their corporate and commercial team, and I've been doing that ever since graduation. I'll hand over to Gareth now just to sort of run through the introduction and what we're going to cover today.
Yeah, thanks, Chris. So what we're going to cover today, hopefully you can kind of see these slides. Do obviously let me know if not, but we're going to look at these main different types of businesses today. I don't want to spend loads of time on this slide, but just this is an idea of what we're looking to cover. And obviously the main thing we're going to focus on is some of the advantages and disadvantages of these different types of business or business mediums, going through each one in turn. Chris and I are going to take alternate slides just so you know how it works. And as we come on to the latter points, perhaps going to focus a little bit more on limited companies, because certainly Chris and I feel that might actually allow the most flexibility of the different models, and we'll explain a bit more as we go through. So Chris, over to you for the next slide.
Thank you. So first we cover sole traders. This is the simplest form of business. The typical example you'll see is tradespeople. So electricians and plumbers tend to operate as sole traders. The massive advantage here is that the form of business has no formality behind it and very limited formality. So there's a low administration cost in running your business in this method. It does have some large drawbacks though. The issue here is that there's no separate legal identity between the business and the individual. So there's no limited liability. Now, Gareth will go into this in a lot more detail later on, but simply in this scene, what matters is that the personal asset, your personal assets can be drawn into the business. So if the business ever gets into debt, your personal assets can get drawn in to pay off that debt. So that's quite a large drawback to the sole trader model. So this lack of legal form also creates challenges when trying to get investment later on in the life of the business. So it's not an ideal model to start off with. Gareth, do you want to go into partnerships?
Absolutely, thanks, Chris. So obviously just comparing and contrasting that model with partnerships, some of you may have some experience of this. And I think one of the main advantages of partnerships is the kind of lack of administration or formality in terms of filing of documents. As you'll see here from the slide, you don't actually have to file any documents anywhere, which will differ from some of the other models we're going to look at in a moment. There's no initial formalities, albeit as we see under the disadvantages, most people setting up a partnership will enter into a partnership agreement. So that's a kind of contract or formal arrangement between the partners to set out some of the arrangements that they wish to make between them, because if they don't do that, just very briefly, you do have to fall back on an act, the Partnership Act, which is a lot more arbitrary and not suitable for lots of partnerships. And as Chris was just mentioning, in terms of legal entities and separate legal entities, again, a partnership is not a separate legal entity from its partners. We talk about joint and several liability effectively. So another disadvantage is any one partner binds all and any other partners that are part of the business. A definition of a partnership is 2 or more people working together in business. So there's always that requirement of at least 2 people. The problem is is if one acts and enters into a contract or obligations with a third party, then they bind the others. And so everyone is jointly and severally liable for debts and obligations that are entered into as a result. And the big thing is, again, as Chris mentioned, is this idea of personal liability, this unlimited liability. And we'll compare and contrast that later on in the slides. Okay, back to you, Chris.
So cooperatives is the next one. These are enterprises jointly owned and democratically controlled by and for the members of the cooperative. So the democratic model is really interesting, actually. Every member gets a vote on cooperative matters, which can be really good if you're working in groups of people to a common goal. So the democratic model also lends itself to really stable leadership. So some of the models we cover later on can suffer by sort of being driven by a single managing director, whereas this model has the entire group take part in the leadership. So it can be much more stable over time. The cooperative is also a separate legal entity. So as we've discussed, it doesn't have the same drawbacks as sole traders and partnerships with personal liability. So there are some disadvantages to the model. The democratic leadership style can actually be a disadvantage because it can slow down decision making for the cooperatives, so they can be less agile in the market. The style can also be poorly equipped to deal with internal disputes. So this is another issue that as the cooperative grows and time goes on, the democratic way that it can be run can actually hold up disputes and cause issues for the partnership that may not be there under other models. So the cooperative model also doesn't really appeal to investors because of this democratic structure. So it can be hard to grow a business under a cooperative model. There's also increased regulation in cooperatives compared to limited companies, which we'll go on to later. So also can be quite onerous to sort of manage. Gareth's now just going to go through charities, I think, Gareth.
Yes, indeed. Thanks very much, Chris. So charities, obviously, this is something that I suppose a few of the people watching might be interested in. And certainly for those who know a little bit about charities, one big advantage is that kind of status that a charity gives you, this idea that it can help promote the ideals and the public image, as the slide says here. And that might be very important, particularly to your respective businesses. One thing we kind of wanted to highlight here is that a charity may seem kind of very positive and for that reason perhaps relaxed, but actually in reality there are a number of requirements that a charity has to comply with. So I think the main message here on this slide is just remember some of these kind of challenges, maybe not always disadvantages, but some challenges that you have to consider when setting up a charity. There is a lot of regulation. You do have to register with the Charity Commission. There are trustees that are appointed. Those trustees have duties to the charity and they form a board of trustees. And so not dissimilar from directors of a company, which we'll come back to, there are those kind of responsibilities to think about. You have to have this public benefit. That's a really important prerequisite of a charity. That may be defined in different ways depending on what you're setting up, but you have to prove to the Charity Commission that you have that public benefit to an identifiable part of the public or a section of them or the public at large. And so it's just important that you remember that there are kind of filing requirements, there are various things you have to do and hoops you have to jump through. And obviously there are limitations as a result in terms of what profits you can make or personal profits you can make, where that kind of conflicts with this idea that charity must be for the public benefit. So that's one particular challenge if you're looking primarily to set up a business for a return or for personal profits, and that's one problem with setting up a charity. Okay, back to you, Chris.
So we have a really interesting model here, which is the community interest company or CICs. So these are essentially limited companies, which we'll go into a lot more detail about in the second half of this presentation. But the key difference you need to be aware of here is that they need to be run for the benefit of a community or to pursue a particular social purpose. So they can be sort of quite good entities to use. They're practically a halfway house between the sort of charity model and then just a full private limited company. So they do have their advantages, really. They provide that positive public image still, while also having many of the practical benefits of a private limited company. So private limited companies are famed for good management and ownership structures, which a community interest company can also benefit from. So there are drawbacks, though, as with all these models, where CICs are always bound by their original objectives. So they must pursue the same social purpose, or benefit the same community they were initially incorporated to do. So this can mean that they're quite rigid. There are also restrictions on distributions of profits of a CIC and restrictions on the pay you can give to your directors. So again, this can be quite oppressive. You don't have the same freedoms that you necessarily have with a private limited company. So there's also obligations, well, extra obligations of transparency and additional regulations on CICs. You need to file an annual community interest report and maintain a higher standard of record keeping within the company, which at an early stage can be really quite oppressive when you're starting a business. There's a lot of regulation to get your head around, and also, like I say, the obligations of transparency, meaning the CIC needs to be run sort of really well from the get-go, which can be tricky. So Gareth's now going to go on to limited companies, I think.
Okay, yes, thanks, Chris. Now, we've tried to be as objective as we possibly can so far in the different models that we've gone through, but you can probably tell from some of the stuff we've both been saying, I think we're both personally on the same page here, that limited companies may actually result in some of the most benefits that you may be looking at, particularly from a kind of startup perspective. And we want to explain a little bit more about that over the next few slides, but I just thought I'd start off here with talking about some of the general advantages and disadvantages. A few of these we've alluded to already. The big one being that limited companies do involve a separate legal entity. Okay, so you don't need to know loads about the legal background to that, but effectively what that means is what's known as limited liability. The individuals that are involved in a company therefore can be protected by this legal concept effectively. So as Chris will come to in later slides, or we'll both come to, if you're an individual involved in a company, be a director and or a shareholder, what you can do is sit behind what we often describe as a kind of veil of incorporation. That means that you can protect your position, and most importantly is that differentiates you from other models like the sole trader or the partnership, for example, where there is unlimited liability. So if a third party comes against you in relation to a dispute, there is no limit to the extent of your liability, so your personal assets may be at risk. With a limited company, what this creates is a vehicle, a business model to hide behind that, and therefore, generally speaking, your personal assets are not at risk. Now, there are certain limited exceptions to that, which we might mention later. For example, where you might give a personal guarantee to a bank, for example, but this is one big advantage of the model. And as Chris will talk about in a later slide, this vehicle also encourages investment. If you're looking for investors from outside, lots of them kind of like to see that you've got this model set up, or it offers that flexibility to investment as well. Now, there are disadvantages. It is burdensome compared to some of the others. It's probably similarly burdensome than a couple of others that Chris and I have mentioned. There are legal formalities. There is Companies House. You have to register your company at Companies House. That is a public arena, so certain information will be available about your company on the public record. There is certain information that you can keep private. Again, we might come on to that later, but don't forget that there is this necessary admin burden, which we think obviously is worthwhile, but there is this kind of burden to it. Okay, back to you, Chris. Oh, I think you're on mute, Chris.
Oh, sorry. So the very basics of a private limited company here. You've got the shareholders and directors. So shareholders are the owners of the company. They literally hold shares in the company. So often these will be ordinary shares. This is what we see in most companies, most private limited companies. And the holders of ordinary shares are entitled to certain rights. So this includes a right to vote on shareholder matters. So these will be constitutional decisions of the company. A right to a dividend, which is a distribution of profit. So if the company makes money, it can declare a dividend. If you hold ordinary shares, you can receive the dividend. And a right to a share of the proceeds of the sale of the company when that time comes. There can also be other classes of shares. It's not just ordinary shares. You see all sorts of different rights. So common ones are either non-voting shares or shares that entitle their holders to preferential dividends, which means they get paid out the profits before the ordinary shareholders. That's quite common. Shareholders also bear the risk in a private limited company. So the money they put in for their shares, the capital, is what's at risk if the company gets wound up. So if there's ever a time where the company doesn't have sufficient money to pay its debts and it's brought to an end, shareholders are the very last people to get paid. So that's the risk with a private limited company. So it's borne by the shareholders. So directors are the day-to-day managers of private limited companies. They make all the decisions on management of it. So as a director, you're not ordinarily liable to the company, but you do have duties, as Gareth mentioned before. So two of the common duties sort of to bring to your attention are a duty to act in the best interests of the company, which is fairly self-explanatory, and a duty to avoid conflicts of interest as well. So need to act in the best interest of the company is the key one. A really important part to note as well, which as the company grows will stay sort of centre to the company, is that directors are appointed and removed by the shareholders. So they're always accountable for their decision making. So although they have the day-to-day management decision power, they are always accountable to shareholders in the end. So Gareth's now going to talk about the typical constitutional documents that we'll see when setting up a private limited company.
Thanks very much, Chris. Yes, so obviously, as I was talking about before, I mentioned the kind of one disadvantage or one challenge with the limited company is the kind of admin burden that's involved, particularly at the start. And we'll perhaps allude to this at the end when we come to questions. But one important part of one crucial part of a limited company is the Articles of Association. We sometimes refer to that as the rule book or the main kind of constitution of the company, as it says here on the slides. Now, what happens is if you do nothing and you simply set up a limited company or you buy one, what you can do sometimes is buy one off the shelf, as it's known. So it's one that's readily made, set up for you, and you can simply change its name and it's ready to go. Often what happens there is the fallback is what's known as the model articles. Now, they are articles that will apply if nothing else does. And although they are sometimes useful, often they're not going to be bespoke in any way to your business. And so what often we would certainly advise is that you would amend those articles, create your own set of articles, either amending provisions of the model articles or creating your whole new set of bespoke articles. So there is that kind of administrative part of setting up that company. And very crucially, remember, as I said earlier, this is a public document. These articles are available at Companies House. They're on the public register. And so there is information that will be published about your business available to everyone out there. Now, that's an interesting compare and contrast with a shareholders agreement. A shareholders agreement, I would always describe as a separate contract, nearly always just between the shareholders. You can make a shareholders agreement with the company as a separate legal entity as well, but more commonly, I would suggest it's between the shareholders themselves. This works like a private contract between those parties, and for that reason it's not available to the public. Now that's a real advantage. This is kind of a creation of lawyers over time. It is something that's commonly used practically when you set up a limited company. It can be completely bespoke because it's a contract. It requires everyone's agreement to amend it. It can create a number of specific rights that would never be included in the articles, even if you did change them from the model articles. And I suppose most crucially, it can contain all the information that you don't want out there in the public arena. And certainly, I think Chris and I would both say it's hugely recommended that anyone should set up a shareholders agreement, enter into this kind of contract at the same time as setting up a limited company, so you can govern in particular the day-to-day running, or the most important bits of the running between the shareholders, and stuff that you don't want the general public to know about. Okay, so back to you now, Chris.
Yep, so I'll take you through the practical steps to incorporate a company. So this is your how-to guide of how to set up your first private limited company. So you need information initially to get started. So this will obviously be a company name. You can search the Companies House website to see if the name is available, because you're not allowed to have the same name as a company that's already registered. There's also rules about how similar a name can be. So as I say, it's all publicly available information though. So Companies House search will usually direct you to where there are names available. You also need to know your registered office. So this is where post for the company will be received. So it's usually a good idea to have an easily accessible address down as your registered office. A lot of law firms offer a registered office service. So this means that documents can be served to the lawyers for a company and then sort of fed back to the client. You'll also need to know your initial shareholders and directors. As we discussed, these are really key positions in the company. So you'll need to know all their details. So certain of their details will be kept on the public record. You can now have your residential address taken off the public record and have a correspondence address as the registered office. But other details will be kept on the public record, as you'll see on Companies House Online. You'll also need to have your articles of association. As Gareth said, the model articles can apply automatically, but we really do advise that you sort of have a brief look at sort of amending them and making them a bit more bespoke in almost all cases. A shareholders agreement is ideal, but you don't need to file this as it's a private document. So you don't need to worry about that on incorporation when registering at Companies House. So in the olden days, you'd file a form IN01, interesting, which is still available now, but they do offer an online incorporation service, which is much faster and easier to use. This is on Companies House Online, and it only costs £12. So it's a relatively low sort of hurdle to get over when setting up the private limited company. The big thing I can stress here is you've got to ensure that the information is correct on incorporation. So although this is something you can personally do, it doesn't hurt, and I mean, obviously we would say this, but it doesn't hurt to sort of instruct solicitors to carry this incorporation out for you, because once you've incorporated the company, to rectify any incorrect details or to change the articles and make any amendments then needs to follow a company law procedure and requires Companies House filings. So it's much more burdensome to correct everything once it's been filed. So it's best to do it right the first time. So Gareth's going to talk now a bit about how we can protect green principles in private limited companies.
Yes, thanks, Chris. So obviously this will be of interest to a number of you watching this video. And obviously, as we've said, I think Chris and I both believe that a limited company can add flexibility. And I think there is often a perception that a limited company may seem too corporate in some way or too business oriented to be suitable, particularly where you're a startup or particularly where you're a sustainable startup. And I think we would say that isn't necessarily the case. In fact, because of some of the things we've laid out, there's a number of ways in which you can make the flexible model of a limited company appropriate for a sustainable business or green or to have green principles, to put it another way. So there's various ways to do that. I think a big key document will be the shareholders agreement, which we've talked about a lot in detail already. As we've said, it's private. It is a contract between the parties. It can contain as much detail as you want in terms of those principles that you want to protect, and it can be enforced by any individual against the other individuals that are a party to that. So that's really crucial in terms of keeping your green principles all the way through and making sure that they don't get diluted or changed. And I think that may be something that there's a risk with other forms of business that we've talked about today. A shareholders agreement can kind of keep that going throughout your business. Also, what you can bear in mind, as Chris has mentioned earlier, is the idea that directors do have limitations on their power. They have to act for and on behalf of the company. They cannot act selfishly. They are the managers of the business, and therefore, if your business is set up via its shareholders agreement, via its articles, in terms of green principles, then they must act for those green principles, if that makes sense, throughout their engagement as a director. So because they have these duties, for example, the duty to promote the success of the company at all times, they must continue to promote and further these things. So whoever you get in to become a director, obviously you may start with yourselves being directors, and you hope you would always have those principles close to your heart. But if you're ever bringing someone else in, what's important is they must also accord with those principles of the business. And finally, we talk here about the object clause. Now, once upon a time, objects clauses used to be very, very crucial, because you had to have an objects clause and you had to set out the objects of your business. And if you didn't, you could be acting outside of your powers. And that was quite funny, because you used to get really, really, really lengthy objects clauses for pages and pages and pages, because people wanted to include absolutely everything in there so that they would be acting lawfully. That's not an issue anymore. However, you can still, of course, have an objects clause. And one thing I think Chris and I would say is it's quite a useful thing to be able to do, to put in your objects, that is the central aims of your business, these kind of principles that you're seeking to protect. And if you've got them enshrined there in the objects clause, really anything that flows from that, be it the articles of association or directors' decisions or the shareholders agreement, even, you can always come back to the objects clause, and if you're offending that, then action can be taken quite quickly via one or other of these avenues. Okay, back to you, Chris.
Yep. So there's big issues that you'll come across when sort of running a limited liability company, private limited company, and you need to keep an eye out for these key issues. So hopefully this will sort of flag them to you now, so later in the line it's not a complete surprise if you do face these issues. So basically, when trying to protect the principals, you're going to have to watch out for institutional investors. So these are a place like private equity houses, venture capitalists, sort of huge sources of investment for private limited companies, which is really good, but they will expect significant control of the company. So usually they'll expect a large shareholding in the company, a director's position at least, and a veto on certain matters, and that's quite extreme. So they'll usually have it so they have pretty much full control over certain decisions of the company. That is the most extreme example. There are plenty of other investors out there, so don't let it put you off. Those other investors won't expect the same level of control as the sort of big institutional investors. They will expect a sort of reasonable shareholding still. They'll want to be able to block certain shareholder decisions. That would be quite normal if they're putting a significant investment in. And usually a position on the board of directors, at least to observe the board of directors, and often to have a vote as well, and to take part in the decision making. The takeaway from it really is you need to find investors who align with your ideals, because the issue is that they will always expect some sacrifice of the control of your company for the money they're putting in. So really do take your time to find the right investors if you can, because it's quite difficult to sort of protect everything if you're still taking investment into the company. And then on a company sale as well, so an exit from the company, the reality is it's nearly impossible to protect business principles when you're leaving a private limited company from the purchaser as well. If they want to change the direction of the company, that they will be in that position after the sale. The best method we would advise is to sort of commercially protect those principles. So if you build your brand around these principles in a private limited company and put the value in that principle or principles, a bit like the Body Shop is a reasonable example of it, is the value is held in protecting those principles. So even a commercial purchaser will then be obliged to promote those principles after a sale. Now, there are other forms of sale. So you can have management buyouts where someone will purchase the company from you, but you will also remain a part of the management structure for a few years in a sort of transition period. So this could help you steer the company after a sale. Again, you can't protect it completely in the long run, but sort of having those few years transition period will allow you to sort of make sure the principles you keep there are protected in the company, and sort of help the purchaser realize how the company should be run. So it's to the benefit of both parties. Over to you, Gareth, for the conclusion, I think.
Yeah, thanks very much, Chris. So hopefully we've kind of taken you through a bit of a kind of summary of some of the business models. Obviously, as you can probably tell, we could talk for a lot longer, but we don't really want to. We want to be able to take some questions and wrap up. But we certainly think, Chris and I, as we said, private limited companies offer that versatility, and we wanted to kind of make this point really because we do feel that anecdotally, certainly from both of our experiences, that people perhaps write off this model, as I said earlier, perhaps because it's perceived to be more corporate or less sustainable or less appropriate for startups. But we do think it is a really appropriate business model. Obviously, we've tried to set out some of the other options, but also tried to explain as clear as we can that they're not all kind of rosy or necessarily less onerous in any way than a limited company. And then there can be these kind of rewards that come from the initial burden, I suppose, or the initial things that you have to do to set up a private limited company. So I guess I hope that's been helpful. Obviously, we're both around for questions. We have had a couple of questions in which I will take first. Then obviously, if anyone else has got any questions, very happy to answer them. So the first question I've got that's come in is in terms of a question around finding a lawyer. Obviously, this is an interesting one for both Chris and I. Chris is a practicing lawyer and me as a former practicing lawyer. And perhaps maybe I'll get Chris's thoughts first as the most recent in practice. We've been asked what kind of ways might you go about finding an appropriate lawyer to kind of help you on the journey of setting up a business, one of these business models, and any kind of tips we can give in terms of navigating that task of finding an appropriate lawyer, anything that we would advise thinking about?
Yeah, so I think it's quite a sort of straightforward answer for this one, really, is if you can reach out to people in a similar business to you, if you know people in your sort of sector, and sort of try and go through word of mouth. So a lot of what we see is people promoted to us, clients come to us through word of mouth contact with sort of other clients, you know, historically or current. And I think if you can reach out to people in a similar sort of market to you and find out who they recommend, that really sets you up for a good relationship with your lawyer, because what you want to do is find someone who understands why you're doing what you're doing with your business. And if you can find that, and say usually if it's people operating the same market space as you, can recommend someone, then they can really build a good relationship. Now, talked about in the past, I think there is a temptation to go for cheaper firms and smaller firms, your sort of high street lawyers, because they can offer sort of quick incorporation services, as we've talked about. I would caution against it, just because the support you get with larger law firms, if you can go for a large regional or national law firm, you have a lot of teams that cover commercial work, environmental work, corporate work. And once you build that relationship of trust with your, say, corporate lawyer, they will then recommend you to someone if you need a commercial lawyer or if you do need an environmental lawyer. And that is just absolutely invaluable, because the time you'll spend searching for an appropriate lawyer at a cheaper price bracket at high street firms and things, you'll end up wasting more time than you save if you go to a sort of bigger, more established firm with more to offer.
Yeah, I think I completely agree with that, Chris. I think the only point I'd add is that obviously it's tempting, as Chris says, to kind of, particularly when you're starting up a business, you don't tend to be making a lot of money, and there may be a period of time where you're perhaps doing this alongside other jobs that you've got, and it may be a little while before you start to realize things. So we've certainly found a lot, Chris and I, that legal advice and paying for legal advice is one of the last things people think about. They're very willing to kind of spend a bit of money on other areas of their business, the branding, the websites, the premises, that kind of stuff. But the legal advice, sadly, comes down the bottom of the list. Now, obviously, the two of us are biased here, but we would very much encourage you to kind of pay almost, it's a little bit like an insurance policy, pay that bit of money, get that advice, particularly if you're setting up a limited company, get those documents, those bespoke documents drafted for you. And then, as Chris says, you can build up that trusted advisor relationship with the firm going forward, and you've always got them on hand if you do need them. You know, hopefully things don't go wrong, but you've got that support network, and that's the advantage of a full service law firm that Chris talks about. Okay, we've got one other question which is specific to zero waste shops. So obviously this is something that we're seeing increased popularity in at the moment, and really it's from someone who runs a zero waste store, and they're looking for, I guess, some advice as to which one of the business models that we've set out that they would be that their business would be most attuned to, I guess. Chris, I don't want to put you on the spot again, but any thoughts from yourself, obviously?
Not to repeat the same message in the presentation, but I would be tempted to say a limited company would be the most versatile sort of body for it. I would say it does depend on the goals as well. If your goal is to have the single store, it's a small business, you're not planning to expand or have multiple people involved, maybe a sole trader works for you, maybe a cooperative if there's a couple of people involved, but it is a smaller scale. But I would really caution it, if growth is on the cards at all for the business, a limited liability company is probably where you want to aim, just because it offers the same protections, essentially. You can still have all the benefits of the other models, but it also allows you the versatility going forward, and you don't want to artificially limit the business at such an early stage. So yeah, I would say it does depend on what your goals are for the business, but I definitely think limited liability companies provide the most versatile vehicle.
Yeah, I think that's a really interesting point you said, Chris, about the kind of articulating where you can go. I think it's very common when you begin a startup, you see yourself, or maybe yourself and a friend or a couple of others that are interested, and think, okay, well, I think we're up for a cooperative or a partnership, or just me going alone as a sole trader, and that's there's no admin burden in doing that. So let's just start it up as soon as we can and get going. The danger is down the line, as we've hopefully set out in this presentation, is that where you're setting up some of those models, you are kind of prescribing how decisions are made, and you're also involving everyone in the decision-making process to how things will change over time. So as Chris says, where you're looking at expansion, 2 reasons that you may be curtailed from doing that is that if you want to take on new people or new premises or change the ethos in your business in some way, you've got to get everyone on board, and everyone has an equal right and an equal say, which can be challenging if your views start not to align or people want out of the business. In addition, if you are looking for a bit more money to be able to pay for premises or new stock or whatever that might be, again, you're a bit limited. It needs everybody's vote for that to take place. And also, as Chris pointed out earlier in the presentation, some investors may be put off by that model as a result, particularly with a cooperative. In my kind of anecdotal experience, you're often finding investment from the community, which is obviously something that accords with values, and that can be a good thing. But the downside of that, where you're taking in that kind of private investment, there's additional challenges you're getting from that, and you may have to prescribe a particular way in which you're taking on that investment. And there may be more flexibility from an outside commercial investor. Okay, so those were the 2 questions that came in as we were talking. Obviously, we're very happy to take any more questions that may come up. I don't know if there's any others that people wanted to raise. Feel free to unmute your mic if you want to do that. I'll probably stop sharing these slides so I can see my chat box as well. But I don't think there are any chat.
Hi, it's Terry here from Australia. I'm sorry I can't put my camera on. I've been having computer issues, which is why I was so late popping in. But I've just been asked to chime in and just perhaps just add a little bit. I'm a lawyer here in Australia, so similar laws, I think, to the UK. But I understand that you haven't spoken about employment issues. So one little thing that I would say, and I'd be interested to hear what the other lawyers have to say about this, is I think it's good to get your employment, basic employment issues looked at from a lawyer right from the get-go, because just to get those basic things right. So for example, an employee handbook can go a long way, and you know, in that employee handbook, you can have your vision and your mission and all those types of things in it as well. So yeah, and just to get your policies in place and just so that you can drive it the way that you want it to be driven. Yeah, that was my little 2 cents worth.
No, I like that, Terry. I think it's important because obviously, as a former litigator myself, obviously, I can definitely, you don't want to wish bad things to happen, obviously, but some of these prevention is always better than cure, I think, and it certainly protects you in various ways. And where Chris was talking earlier about the actual incorporation of a limited company from another model as well, there are those hurdles to jump over as well, because where you're creating a separate legal entity, obviously you've got to think about the various legal documents you already have in place and whether or not they're automatically going to stay in place when you change your business model. So Chris, I don't know if you had anything to add on that.
Yeah, well, it's just interesting from a corporate perspective. It often comes up on company sales, and again, if you can have your employment affairs in order, I mean, it's the same message we're giving with the incorporation documents. Essentially, is investment at the start just pays dividends later on. You know, if you can get your company in order, both employment aspects, you know, every aspect of it, straight from the get-go, you are just saving yourself a massive headache later on in the company's life. Even if there aren't necessarily employment issues along the way, just having that good admin and that good sort of base to start from is really, really helpful. And we see it benefit people all the time if you can take that proactive approach rather than being reactive to issues when they crop up later down the line.
Yeah, I think that's right. And also just on another aspect of it, if you're looking at you know, if you're thinking about sustainability and social impact and all of those things, you can really drive your culture by getting those things right. I think sometimes people think it's just HR, But if you get those employment documents right, you can really drive your culture as well. That's my view.
No, I think that's right, isn't it? At the end of the day, there's whatever model you're choosing, you've got individuals involved in it, and you've got to get them kind of on board with what you want to achieve. And it's all well and good setting this out in documentation that we've talked about today, but if you've not got the individuals to actually want to run it in the way that you do, then that's going to be very difficult for you going forward. So I completely agree with that.
Thank you for listening to me, and I'm sorry to pipe in at the last minute.
No, it's great. No, I appreciate it. Okay, so I don't think there's any more questions coming through. So obviously we'll draw this to a close, but I'd just like to say thank you again to Green Springboard for inviting Chris and I to talk tonight. I hope it's been helpful for anyone tuning in either on the recording or live tonight. And I think we'd be very happy to answer follow-up questions if anyone watches this and wants to get in touch with Chris or I. I'm sure you can get in touch via Green Springboard on their various channels, and we can answer further questions if need be. But thank you very much for listening, and I think we've both enjoyed it, haven't we, Chris?
Yes, yeah, thank you for Green Springboard again for putting it on, and yeah, more than happy to answer questions if people have them. So if you go through Green Springboard, you can get in touch on any sort of company or commercial law matters. Thank you.